Another of his sayings was that most men were within a finger's breadth of being mad. If then anyone were to walk along, stretching out his middle finger, he will seem to be mad. But if he puts out his forefinger, he will not be thought so. Those words are from Lives and Opinions of Eminent Philosophers by Diogenes Laertes, describing the Cynic philosopher Diogenes of Sinope. It seems that stretching out one's middle finger has been a part of Western culture for over 2,000 years. That was no different recently in Des Moines, Iowa, where someone stretched out his middle finger, and in response, the police trumped up charges and beat him up. Also, they may have racially profiled him. We'll talk about that case from the Eighth Circuit and another First Amendment retaliation case from the Sixth Circuit where they took away someone's pension this week on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, March 12th, 2025, and I have two of my Institute for Justice colleagues with me to discuss these matters and what ever else is going on in the world. They are Jaba Tsitsuashvili and Robert Fellner. So welcome to you both. Now, Jaba is an old-timer on Short Circuit, and we'll get to him in a moment for this Eighth Circuit case. But we also have our first-timer, Robert. So, Robert, you are now working at the Institute for Justice. You're a graduate of down the street at George Mason Law School. But before that, you spent a good deal time out west in Nevada. Is that right?
Yeah, I was living in Nevada for about 17 years prior to coming out here to go to law school at George Mason and then land my dream job here at the Institute for Justice. Nevada's awesome, not least of which because it has no state income tax, which moving to Virginia has made me appreciate greatly. But it's just like, it's such a great town. I mean, obviously it's very hot, but I like it. It's a dry heat. That does matter. No humidity means no bugs, no mosquitoes.
And not hot at night, right? Unlike in Virginia.
Right. I mean, although in the summer is brutal. Because like the lows at night are still like 85, 90 degrees.
Okay.
But if you're in the casinos, it's air conditioned. It's okay. And I just love, the scenery, the Red Rock Mountains, the desert is beautiful. And having said all that, it's nice to... 17 years is a long time to be out there, and you do kind of miss the seasons because it's either sunny and hot or sunny and cold. So it's nice to see the vegetation and have real seasons again.
So my favorite constitutional fact about Nevada is, see if you know this. So can you name one of the stenographers of the first Nevada Constitutional Convention, which I think was like 1862-63.
Yeah, you lost me at stenographers.
Well, it's kind of a little bit of a trick question, where you just wouldn't know, because one of the stenographers was Samuel Clemens, otherwise known as Mark Twain. And It was pretty early in his career. His brother was like part of the proceedings, so he got the job as a stenographer. Which I don't think he was super happy about. I think later he was very much more okay writing than doing shorthand. I don't even know if he did shorthand, actually, because he said that he was not fond of this job, but he did say that Nevada was a good word because you didn't have to lift your fingers and dot the I's or cross the T's. So I guess he was just, writing it longhand, it seems. Anyway, this is not about Nevada. This is about Des Moines, Iowa, where Jaba's going to take us, for this young man maybe made not the right choice in what he did with his middle finger, but certainly did not deserve what happened to him afterward.
Yeah. Well, right or not, what he did was constitutionally protected. So just to walk through the sequence of events here, he's driving down a road, and the police, I think what happens is that the police start to follow him, right? Before he makes his his choice. So he, you know, he's it's at night. He's driving down a road, and this, I think, is where the kind of initial kind of racial profiling aspect of it comes in, because before he does anything, the police start to follow him, and then he proceeds to, for I think, I forget exactly how long, but several blocks, he's kind of driving with his middle finger up at them, um, as he's going about his business. And so they continue to follow him, right? Which, again, what is now let's ask ourselves, why are they following this guy who is just driving down the road with his middle finger up? Well, obviously, it's a situation where they're upset about the fact that he has a middle finger up. They can't constitutionally stop him for having his middle finger up, but if they can manufacture some sort of probable cause to think that he might have committed a traffic violation, no matter how minor, right? Then they can stop him, and all bets are
And
off,
if it's a
right?
pretext, that's totally fine.
Well, according to the Supreme Court, if it's a pretext, it's
That's what
totally
I meant.
fine.
Yes.
Yeah. So we have there's a Supreme Court case known as Wren that says that pretextual stops are totally fine, and the pretext can be, again, here there's kind of, you can imagine two underlying potential pretexts, right? One is the potential initial racial profiling of them, and the second, which is more kind of jumps out and is obvious, is the pretext being the fact that he flipped them off, and continues to flip them off for a little while. So they keep following him, following him, and following him, because they're trying to manufacture, in essence, a reason to stop him, right? Because they know that the second he goes over the lane marker even just a little bit, well, there you go, there you have it. That's probable cause to pull him over, and potentially even arrest him, try to gin up some sort of potential probable cause to search his car. So it's a cascading effect that comes from the ability to engage in this kind of, again, what we all, I think, understand and know is a pretextual stop, right? So that's what happens, but things are even more interesting than that, and even worse than that, because in the course of then proceeding to prosecute him, or well, we can actually, before we even skip to the prosecution bit, um, they rough him up, right? And they
Right.
make statements on their body cams, essentially indicating that there's actually a news article that came out shortly after this all happened that kind of explains a lot more detail about what happened. And it says, on the video, the two officers are heard saying during the stop, saying they would have let him go with a verbal warning had he not been disrespectful to them, right? So it's this age old situation of what's being come to be known as contempt of cop abuses, right? It's basically, if the cops don't like you, they can always gin up some
Right.
reason to take you in, to rough you up. And so they bring a prosecution against him and the allegation is that at a certain point, while they're following him on these many, many blocks, I think it was 11 or 12 blocks is what it says, they keep following him, following him, following him, and eventually he comes to a red light, and he makes a right turn. The turn itself at the red light is lawful, but what they say is that there was a car coming the other way that had to supposedly kind of hit its brakes a little bit as a result of the red light right turn that he made. So they bring a charge. The charge that they bring actually ends up getting amended by the prosecutor to one that's actually the correct one. Because, again, you got to remember, all they're doing here is trying to come up with some reason to charge this guy for something under this kind of, what we all understand is this contempt of cop situation. The prosecutor changes the charge. He gets convicted. Now, in the course of that prosecution for this traffic violation, um, they do not release any of the either body video or, more crucially, the dash cam video of what happened, right? Because the cop car is right behind him. The dash cam will show you both the turn that the guy made, that the plaintiff made, and also the car that then comes, that they say have supposedly had to kind of brake a little bit. They don't release any of that. He gets convicted. Eventually, the dash cam does come out, And what it shows is two things. And I think the second thing it shows is way more indicative and interesting here than the first thing it shows. The first thing it shows is that this car didn't really have to. This car that was coming across the intersection, it didn't slow down. It seemed to me like it was going at a pretty consistent speed as it went through this intersection. The plaintiff did not really slow him down at all. Okay, maybe there was some indication that the speed changed ever so slightly. Okay, fine, I'll spot you that. But then what do the police officers do? The police officers then speedily make the same right turn as the plaintiff did, right? And they then charge into the left lane, the opposite traffic coming the opposite way. They charge into the left lane, and they cut off the guy that they accuse the plaintiff of having cut off. They really aggressively like charge ahead. They cut that guy off. There's no way. I guarantee you, there's no way the guy didn't have to slam on his brakes when the officers cut him off, right? The officers cut that guy off, zoom through left lane traffic to pull over the plaintiff, the guy who, our friend who had been flipping them off for about a dozen blocks. So it's really this beautiful kind of like confluence of them doing it way more dangerously, way more conspicuously, way more just obviously what they accused the plaintiff of doing. So that, remember, they refused. They had that body cam and that dash cam video when they prosecuted him. They refused to release it. Eventually, after the conviction, it does get released. He moves to have the conviction set aside. He succeeds in having the conviction set aside, and now he's able to bring a Section 1983 lawsuit for the various constitutional violations that the officers committed in the course of this arrest, right? In this arrest and this conviction. And that includes, he brings claims for retaliation. He brings claims for illegal search and seizure. He brings claims for excessive force because they slammed him against the hood of the car when they were arresting him. So there's this kind of litany of harms that flow from not just the initial stop, but also the refusal to release the dash cam footage, which clearly showed that, to the extent anybody really cut off that random driver on the road that night, it was the police. Right. To the extent that anybody manufactured some sort of potentially dangerous situation that night, it was the police. The police then obviously move for qualified immunity when the 1983 lawsuit comes, and the district court actually denies immunity, and the Eighth Circuit affirms the denial of qualified immunity for the officers. So what we have here is, at the end of the day, it is the right outcome. But mind you, this opinion came out a couple weeks ago, right? The incident happened in the summer of 2020. So years later now at this point, where we're still litigating whether this case will even go to trial.
Well, sorry to correct you. I think it was 2018.
Oh, was it even 2018?
2018, yeah. But I think that it might have been the reporting about that video was in 2020.
Okay,
yeah, so
my bad.
Even
yeah,
longer.
So even way longer. Yeah. So long story short here is that this is not an unusual or unique situation where the officers, either for be it racist reasons or just First Amendment retaliation reasons, if they don't like somebody, if they don't like something about you, all they have to do is gin up some reason for a traffic violation, and then they can arrest you. They can try to find reasons to search your car. They can rough you up, and then it's incumbent upon you to beat that all back, both in terms of avoiding a prosecution, but also then overcoming qualified immunity if you do sue. There's one other aspect that I'd be remiss not to mention here, since this is actually a big aspect of IJ's work in the immunity and accountability space, which is that if he had not succeeded in getting that conviction overturned, he might well have potentially all of his claims, but at least some of them might well have been what's called heck barred. and he would not have been able to bring his Section 1983 claim basically at all for most of those claims if he hadn't succeeded in getting that conviction undone. And remember, the only reason he was able to succeed in getting that conviction undone was because eventually he was able to access that dash cam footage that they withheld when they initially prosecuted him. So um, I don't know that I have a big kind of bow to put on this thing, other than just the fact that like all of these things compound to make it harder and harder and harder to achieve some measure of accountability for these kinds of violations.
Rob,
Java, can I ask? Yeah, I was going to ask legal questions. I'm still learning here. Am I correct that the dash cam video had to show that the officers had no probable cause to pull him over? Because if they did have probable cause, wouldn't that be the Nieves rule that defeats a claim for retaliatory arrest? Or have I got that wrong?
So you're saying, well, the you're asking whether the Nieves rule of probable cause for arrest would defeat the retaliation claim, right?
Right.
Is
Like
that what
if
you're
the
saying?
video shows it was, maybe he did do something wrong in
yeah,
terms
he
of a
went
traffic.
over a white line or
I
whatever.
hear, yeah, yeah. So that is that. So I get what you're getting at. Is the question of probable cause basically, and yes, and in the Eighth Circuit's opinion, what they say is that the district court held that there were fact disputes as to whether or not there was actual probable cause to pull him over. So now, mind you, in the criminal proceeding, it ended with an indication of innocence, but obviously, probable cause and ultimate innocence or ultimate guilt or innocence are not quite the same. But yes, the dispute of fact that remains in the trial court when this goes back down, and which is going to go to a jury, is whether there was, in fact, probable cause for the stop.
Right.
And if
So
the jury says there is, then the cops are immune.
I think it's less a question of immunity at that point. It's more of a substantive issue that the Supreme Court created, like you noted in Nieves, of if you have probable cause for an arrest, then it becomes much harder to make out a First Amendment retaliation claim. Now, we've succeeded in our Gonzalez case of last term in paring that back a little bit. And so, like, the question of how broadly to interpret Nieves' rule about, probable cause always or sometimes or never defeating a retaliatory arrest case is still being kind of hashed out. But yeah, Nieves did create that rule.
I think that's a great point, Robert, to bring up Nieves, which I can never pronounce correctly, is because there's kind of two things that are in the shadow in this case that the case doesn't really get into because it said there's dispute of fact. One is qualified immunity, and the other is just does this violate the Constitution, which I don't know, looks pretty obvious to me. But then there's the Nieves rule, and then as Jabba said, there almost was the heck bar. So it's just all these hurdles that this guy has to try and get over to fight back against what is pretty obviously, once you see that video, a pretty unconstitutional situation. I had a question, Jabba, if you know about that, the initial trial, so his initial prosecution, it looks like he was able to kind of move for reconsideration or something in the state court after his initial conviction. Like it's not like he had to appeal up to the Iowa Court of Appeals or something to do that. So that's pretty. I mean, it just seems to me because I think he was pro se, right? That's pretty savvy work to lose on this conviction, somehow still get. I don't know. Maybe he was being stonewalled for the video, but after convicted, like they're like, fine, have the video now, and then he was able to move to reconsider. Do you know anything more about how that played out?
Yeah, I didn't dig too deep into the how that all came about, but I think your intuition was kind of mine too, which is that like once they secured the conviction and they thought that they were kind of free and clear, maybe they were their stonewalling kind of crumbled a little bit more, because you got to remember at the end of the day that he had a right under, I think, state law to get that video. But what happens is a lot of times when these good laws get passed for transparency, be it about body cam videos, dash cam videos, police departments, sheriff departments will then kind of institute their own policies about the circumstances in which they'll actually comply with that law and actually release these videos. And you won't be shocked to hear that those policies usually mean, oh, we're only going to release it if we feel like it.
I do have to say it's good that when he flipped the bird, that he only did it with one hand, because long time ago, a friend of mine had a story that there was a kid he grew up with in town and saw the cops when he was driving a car, and he flipped the cop off with both hands, and then he was pulled over and ticketed for driving without any hands on the wheel. But of course, one,
that makes more sense to me. Honestly, the other thing that I wondered about was how they could, if he was doing it within the car. It was nighttime. I was wondering if he had his hand out the window, or like it was left hand out the window, or if it was right hand in the car. Because if it was right hand in the car, what that also makes me believe is that the cops were shining a light into his car, because at night you usually would not be able to see that.
And it's a little more understandable at that point why he would be like, what is going on here?
Right, exactly. Yeah. And so, and I'm not sure of the answer to that, but there's a lot of aspects of this that, like, it should have never gotten to this point. Mm-hmm. But again, he had every right to flip off officers that were number one following him, and again, possibly like shining a light into his car or in some other way, kind of just making him feel uncomfortable and harassed,
Well, someone else who felt harassed was Dwayne Seals, and this is a case from the Sixth Circuit, Seals versus Wayne County, one of our favorite defendants at the Institute for Justice, Wayne County, Michigan, which of course is where Detroit is. And this man was complaining about how people were being treated with their pensions, and Wayne County did not take too kindly to that. So, Robert, what's going on with this guy?
First, that was just an incredible transition, Anthony. Very well done.
Thanks. Well, let's see what you can do now.
Yes. So yeah, in Wayne County, Michigan, there's a government employee, Dwayne Seals, who worked for Wayne County for just under 11 years. He retired and began collecting a $65,000 a year pension. About 2 months later, he goes back to work. But prior to going back to work, he wants to make sure he can still collect his full pension while drawing his full salary and benefits for this new job.
Which I have to say is a pretty sweet deal. You go back to work kind of at the same job with a full pension, but we're not getting into pension policy here today.
That's a shame, because I love pension policy. But yes, so what is legally relevant is the statute that enabled him to do that. Because what's really at least funny to me about this statute is normal government employees don't get this perk. It says if you have a pension and you work more than 1,000 hours a year, you lose your pension while being employed. You get it when you ultimately retire, of course. So anyone who works full-time is working more than 1,000 hours a year and therefore can't collect both the pension and the salary. There's an exception to this 1,000-hour cap, this 1,000-hour rule, and that's for high-ranking officials for some reason. And specifically, the statute says elected officials and appointed county officials are just exempt, so they can draw both. The statute does not define what an appointed county official is, however. But everyone's on board that this new job does qualify, so he's collecting both. He brings up a complaint and this is important to note, with the Wayne County Employee Retirement System, which is a separate independent agency from Wayne County, has no control over him or anyone in Wayne County government. The man who appointed Dwayne to this new job says, Dwayne, please stop bringing up these complaints. You're ruffling feathers. I just appreciate it if you didn't. And he said, fine. About 2 years later, Dwayne takes a different job in Wayne County. He starts now working for county clerk's office, I think is the financial officer there. But now that he's working for this different job, he starts bringing up the complaints again. And he specifically is writing to the board saying, the way you're calculating our benefits is wrong. It doesn't really affect me. He even said in writing, it reduces my pension benefits by about $38. But I'm concerned with all the other retirees who are being deprived of their rightful benefits. And this goes on for a couple months. And then the retirement board says, hey, didn't he change jobs recently? I know his old job qualified for that exemption. Has anyone checked if the new job does? The record evidence is very clear. They're not doing this because they're concerned with being responsible stewards of taxpayer dollars. They even say, like, this will shut him up if we can cut his pension. So they ask, because the retirement system itself is, and the law is vague, and they're not lawyers, they ask Wayne County Council, which is a separate, which they have no control over, it's a separate government entity. Can you give us a legal opinion? Because the statute is kind of vague. The lawyer gives them the legal opinion that this new job doesn't qualify for the exemption. So they notify HR. HR says, hey, this new job doesn't qualify for the exemption. If you keep working past the 1,000 hours, you'll lose your pension. He does. The retirement system stops paying the pension, and he sues. He wins. He gets $180,000 from the jury. After the district court held as a matter of law that he was engaged in constitutionally protected speech, which I think is very uncontroversial finding, what becomes relevant is the district court also held as a matter of law that the retirement system took an adverse action against him by cutting his pension. And the jury, I guess, concluded that that action was caused by his retaliatory speech. The Sixth Circuit affirms very light on analysis. In particular, of particular interest to me is the adverse action element. They upheld with one paragraph analysis, say anytime an employer cuts pay, that's an adverse action. And so I don't think there's anything, obviously the employee retirement system was motivated by retaliatory animus in response to his constitutionally protected speech. But I think what makes this case interesting and would have benefited from some deeper analysis here is I don't actually see the adverse action being the cut of the pension. I see it being the request for a legal opinion because the retirement system doesn't have the authority to decide who gets a pension. It's a ministerial duty. It has to file a statute. In this kind of unclear case where no one knows what a appointed county official is, they sought legal advice from an outside agency, which I think is very relevant too. And if that advice is correct, even though the adverse action was, hey, are we complying with the law? It just seems weird that, oh, we now have to comply with the law. You're not entitled to this pension. Their act of bringing themselves into compliance with the law is a harmful action that entitles the recipient to continue to receive a payout for a pension they were never entitled to in the first place. So I don't know. I just thought that was kind of curious. I mean, it's almost kind of like malicious prosecution, where there's this intervening force, right, where the prosecutor is making the decision, and here it's like the outside counsel. And even then, that's not a great analogy because prosecution is like this net harmful act where stopping the payment of pension benefits to people who are not actually entitled to them under law is kind of a good thing from a taxpayer perspective. So I just thought there was all these interesting aspects of the case that the court didn't talk about at all. But I'm not sure exactly, but I think it warranted more analysis than kind of what the court gave it here.
Jaba, your thoughts?
So I think Robert may inadvertently be blessing the logic of Nieves outside of the criminal context, because I think the point that you're kind of making is it's analogous to, well, if there was probable cause to terminate the pension, then should you not be able to bring a retaliation claim? I don't think that's right when Nieves says it, and I'm not sure that it should be right in this setting either. That the mere fact that there may be a question as to the propriety of termination of the benefits um, should defeat the retaliation aspect of the case, right? Because and again, to take it back to kind of the prosecution and criminal setting, the Fourth Amendment and the First Amendment protect different interests, right? And so there may be probable cause under the Fourth Amendment, but why does that necessarily tell us, indeed, why does that um, entirely tell us the propriety of a retaliation claim? It shouldn't, right? And I think that a similar kind of point can be kind of made here, which is that yes, I take your point that the question of whether or not he was actually under the statute entitled is one aspect of it, but there is still the second aspect, I think, of, well, what was the basis for actually doing that? What was the kind of the sequence of events that led there? And I think that it can be similarly separated out from that First Amendment retaliation question can be similarly separated out from that merits question.
And perhaps, so Java, thinking that through, perhaps this case, I mean, there's a number of reasons why it didn't come up in this case. Could be that defense counsel were not very good. But the fact that the Nieves type question doesn't come up here, obviously it's not an arrest. It's just loss of this benefit, and that kind of doctrine that some people think is just so obvious, like Nieves, why it's such a good rule, isn't coming up in this other context because it just that those kind of castles on clouds haven't been created over there when we're talking about pensions that have been created when we're talking about arrests.
Right, and I think that Robert's concern is actually more captured within the kind of causation aspect of the retaliation kind of analysis, right? Because there's these three steps that the court sets out, right? The second one is adverse action, and so like the question of, well, was the the causal force of the elimination of the pension, was it retaliation or was it something else? That gets captured in the third step, and the jury there made the determination that the causal force was retaliatory, and so I think that aspect of it did actually gets accounted for in the First Amendment analysis. And yeah, I think Anthony, you're totally right that that's the normal sequencing and that's the normal course of events outside of the criminal context, outside of this kind of construct that Nieves created.
Well, I mean, one thing I would add is, and I don't know that I have a position on this, but I just think it was worth discussing, is so the Sixth Circuit is citing employer actions, right, of adverse actions, which all involve discretion. And I guess that's the wrinkle I would have liked to see fleshed out is, I know the jury said there was causation, but what I'm saying is if the law says you're not entitled to the pension, the retirement system decision to cut the pension is ministerial. Like they have no discretion to do that. So it does, to me, that doesn't map like real neatly onto like the line of employer adverse action retaliation cases, which all involve an element of discretion where the employer is taking some kind of harmful action. Where here what's happening is, yeah, their motivation to see if they were complying with the law was bad. But like once they get information that they're not complying with the law, that act that the jury here says, oh, that was caused by retaliatory animus, it just doesn't, I don't know, like really like finding out you have a legal obligation to stop making payments is driven by animus as opposed to a legal duty to comply with the law.
Well, it could be. So this may be like really splitting hairs here, but I wonder if this is what was going on with the jury. And the court doesn't get into this, but the jury, so his award from the jury was not like some kind of judgment or direction that he had to have his pension reinstated. It was a jury verdict of $180,000, which I'm guessing is like lost, pension time. So it could be that, okay, legally under Michigan law or whatever, his pension has to stop. Maybe that, they're not going to rewrite the statute. The federal court is not going to rewrite that statute. But nevertheless, it was wrong for him to lose that because of this retaliation. And so therefore the remedy is this chunk of money, which would be the same thing as getting the pension back. Now, who knows what he's doing now? Maybe because once he stops working that job, right, or the hours, he will get the pension back into his retirement. So that I wonder if that's just the way they split the baby, without actually killing a baby.
Yeah, I know. It just feels weird that like the government coming into compliance with the law in a way that's like a public good, not wasting, not spending taxpayer money on things that it shouldn't, that was like an adverse action, like these employers who fired people or cut their pay. It just, I don't know. I thought there was more room to discuss.
It's definitely trickier than, the cop arresting someone for what sure is a violation of the law, but has discretion to do that in all kinds of ways. Kind of like these police officers in Des Moines we were talking about earlier.
Well, the same argument could be made. The same exact argument could be levied there, which is arresting someone who committed a traffic violation is for the good of the public.
Sure.
Right?
Well, well, that can, but I think Robert's point is
it's the same logic, though.
No, it's not.
Well, I think Robert's point is that these people on the pension board, once they receive that information, they're legally obligated. Like the cop is not legally obligated to pull that fellow over, and that.
Yeah,
and
I mean, I don't buy the fiction. I don't think most people buy the fiction that rigid enforcement of the infinite number of criminal laws promotes the public good. But I think, again, this is a very, very narrow circumstance where you have a program that's funded by taxpayers. When the government is operating that program in excess of statutory authority, taxpayers are paying for that. They don't know they're paying for it. It's wrong. Like, we want government to be fiscally responsible. There's I think legitimate reasons to say that's a good thing, where I don't know that there's many people who say the government should be pursued. I just think it's analytically different than, because criminal laws impose real costs. I don't think most people think that the purpose of criminal laws, every single criminal law, is to be maximally enforced. And I think if that happened, that actually might be really good for our cause, because people might embrace limited government. But anyway, so that's.
Part of what's going on in my head is, as a former ERISA lawyer, thinking of the trustees of the trust fund and how they're thinking of this versus the First Amendment concerns, and so they're going to be thinking of it's a fiduciary duty they have to cut it off.
Right.
So there's a lot in play. It's not to say that they should have cut this guy's benefits off once they knew it, even though they was for perhaps unconstitutional or even more heinous reasons. Like, we could come up with some hypotheticals, but I think those are the interests that are that are being balanced in a way there. Also say that this is a jury verdict. So this could be why this is also an unpublished opinion, that the jury found for this guy. Once a jury makes a ruling, unlike in all these summary judgment qualified immunity appeals that we often deal with on this show, the jury has actually spoken here, and they spoke that this guy was wronged, and they're going to give him a verdict. And so the Sixth Circuit is just
the taxpayers of the jury.
Okay, Java, take it easy. Nice little needle.
Well, we will needle more on the next short circuit. But for now, I welcome my colleagues in this debate that we've had today, and discussion of retaliation in two different contexts. So please stay tuned for next time. And in the meantime, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.